So the title of my talk this morning is Advocacy at the Wine Bar. You'll notice there's no wine here. And that's because the entire point of the talk today is to teach you a little bit about the world that I operate in, the legal world, but it's also to equip us as ladies and as the church in advocacy. And I'll explain a little bit about that during the talk. So advocacy at the wine bar, if I just explain, isn't about me being at the wine bar. It's about us being at the wine bar with our friends who might not be, and hopefully aren't Christians, so that we can tell them about Jesus. And so I think there are skills that are important in my profession that actually are entirely transferable to what we do and what we're called to do. Who's who? Let's start with who's who in law, because this is one of those things that actually is incredibly confusing. And it's confusing because there are actually quite a few people in law, and quite a few people, lots of titles are a bit confusing. I've got a pointer, look at this. So there are people or businesses who need help. That's normal people going about their ordinary lives, doing ordinary things when bad things happen. And that's basically what I do. I deal with ordinary people going about their ordinary lives in a context of social housing or landlord and tenant stuff. So you can be living in your rented accommodation, or indeed a leasehold property or a freehold property, and have a problem that might land on my desk, just through being normal in your day-to-day lives and coming across a problem that you hadn't anticipated or you might have anticipated. So you go and see a solicitor, and this is kind of in the order of how things might go. A solicitor is a person who is a qualified lawyer, and the point that solicitors and barristers kind of go their separate ways is after an academic stage. I might be after a law degree or another degree. I have a history degree, and I did a law conversion course. And you go and do a legal practice course, the LPC, if you want to be a solicitor. It's a very practical course. It's a course that I did, and I learned all sorts of things like solicitors' accounts, interviewing clients, how to fill in various types of forms for case management, how to do various administrative tasks. They manage a legal case, they write, and they engage, what we call engage in litigation. Barristers are not allowed to engage in litigation. I do not engage in litigation. Engaging in litigation is a technical term which means writing to people. So I don't write letters to the court or anyone. I don't ring people up. My phone doesn't ring. I have to say, when I became a barrister, that was the biggest thing I noticed. My phone doesn't ring. It's an absolute joy. And then solicitors can actually do quite a lot of work that barristers can do. So when I was a solicitor, I took an extra qualification. It took me a year to obtain, called a higher right of audience. And a higher right of audience is, for solicitors, normally you are allowed to talk to a district judge, which you'll see in a minute is the lowest level of judge, or a magistrate, and you can talk to a circuit judge, which is the next level up, but all within a county court or a magistrate's context. Solicitors don't have a right of audience to talk to high court judges, appeal judges, Supreme Court judges. They will just simply say, I can't hear you. So I got my higher rights. Now what that gave me actually was a shoe-in to becoming a barrister. So I was basically doing all the job the barrister does as a solicitor. When a solicitor finds themselves short of time or short of expertise, they go to a barrister. And this is what I am. And I'm instructed by solicitors. This is where another crossover. I actually could qualify to do with the work that the solicitor does, which is engaging in litigation and taking instructions from people and businesses. I can do that if I want. So there's an enormous overlap between these two jobs. I've chosen not to because I like my phone not to ring. So my job is advising people. So I will get a brief. Here are all the papers. It's an absolute joy. One set of papers or one ring binder comes into chambers, and they'll say, "Can you advise? My client wants to know the answer to this question."
Or sometimes they say, this is an absolute mess. Can you work out the question and then answer it? No, this is basically a huge problem. Can you sort it out? Sometimes I get, we've done all the work. We've got a trial next week. Can you please represent the client at this hearing? And it might be a 10-minute hearing. It might be a 3-day hearing. Sometimes I get, this is the problem. We are now at the point where we'd like to issue a claim. Please could you draft what we call claim form particulars of claim, and that will start the ball rolling. So I'll draft it all, send it to the solicitor, and they will issue, we call it issuing at court, and make the claim in court. And sometimes I get, my client's being sued, please can you draft a defence? So I get all of the papers in and I draft the defence and I send it off. So I do bits of work. I don't have a file and I don't keep cases in my mind. Someone rings me up and says what's happening in my case. I have no idea. My phone doesn't ring. So I do what you might call factory piecework, do little bits at a time. So I get instructed by the solicitor to do bits and pieces, and I give it back to the solicitor. I get on with the next bit of work. Then we get to these big cases that might go on for a year, 2 years, 3 years. And the solicitor will keep me as a barrister informed at various points. So we might have little hearings, we call case management hearings. So we've got claims being made in court. So we've got a claim form, particulars of claims. The particulars of claim are exactly what they are. It sounds like they particularize a claim. So if there's a contract claim, say, particulars of claim, say, there is a contract, you have breached it in some way, that has caused us a loss, and we'll set out what the loss is. And then the defence says, yes, there's a contract, we haven't breached it, your loss is your own fault. Then we go back to the judge, and we say to the judge, we get a 10-minute hearing, it's called a case management hearing. I would represent the client to that and would say, okay, let's say it's about housing conditions. Somebody says, landlord, there's a contract between us, you keep my property in repair. You've not kept my property in repair. And that has meant that I have lost the enjoyment of my house. The landlord says, yes, we have a contract. You never told me your property was in this condition. It's not in the condition you claim it is. And the loss you've suffered is a load of baloney. So what we're going to need is a witness, and that will be our tenant, our landlord, and anyone else might have seen the property. And we're going to need an expert, and an expert is somebody whose job is to advise the judge. There's no such thing as an expert for a party. An expert is appointed by the court to advise the judge on things like property condition. So you get a surveyor to go and have a look, take some photos, and advise the judge on what the condition is on the day. And the judge, when I say manages cases and gives judgments, that 10-minute hearing where we've got our claim and our defence, the judge will say, okay, what do we need? We need everybody to give everybody else the information that the other one's got. It's called disclosure, disclose everything to the other side. We need some witness statements for our witnesses, and they will write down everything that they should say at a trial. You don't keep anything secret, it's cards on the table. And the judge will say, we need an expert, so they'll appoint an expert and give a timetable about when things should happen. So typically you'd say disclosure in 2 weeks from today, exchange of witness statements in 28 days, expert, instruct them in 2 weeks, get the report in 6 weeks and we'll come back. Or we'll, then you have to make a decision about whether you want to get some more case management from a judge or you want a trial. Usually we just list it for a trial, and that kind of case will take a day. So then we'd get in front of another judge, list it for a day, and then in the day, the trial happens in a very systematic way. Claimant goes first, so the claimant's the tenant, and so they would say, here's my witness. You cross-examine the witness. Done. Defendant, landlord comes on. Landlord gives their evidence, cross-examined, and then the judge will give a judgment. Clear as mud? Excellent. Oh, we're going backwards. Right. So I'm a barrister. So I advise, draft stuff, advise, represent in court at these procedural hearings, at final hearings, and then I advise and represent people when they want to appeal. It happens not very often. there are different rules about what you wear. Now, it would be a ladies' morning, if we didn't have some fancy dress. So, I brought my fancy dress. When so there's a table that the Bar Council has put together, and it has all the different kinds of hearings you might have. And it's got 2 columns, one that says business dress. Business dress is defined, by the way. Business dress is defined as black, dark navy or dark grey. So that's my colour palette. And I call it the county court battle suit. And then we've got court dress. So some cases have to have court dress. And this is court dress, which is also defined. Court dress, the gentleman is a white shirt with no collar. And because you're not allowed to wear court dress in the streets, you're only allowed to wear it in court. The gents have a removable collar that kind of got a little button at the back, so they can take the wings off or not. And they take that off, and then they've got bands that they literally just tie around. Ladies, I don't really like to wear a collarless shirt. It looks a little bit not very feminine. And so you get a collarette. And this is basically straight out of ABBA, because you can put it on and then just rip it off. So that goes on like that. And then you get fairly adept at doing the thing off at the back. You've got the robes, straight out of the 17th century. And I say that in jest because the court dress hasn't changed since the execution of Charles I, and it was black because we're still in mourning. The lawyers backed the wrong side. So there's a little nod to the way that barristers used to get paid. When I say we can't engage in litigation, we can't handle money either, and it's so offensive to us to even think about handling money. There's a little money pocket at the back for your client to put a little pocket of coins in, preferably before you've started speaking. So that goes on like that. And then the bit you're all waiting for. So the wig is a short wig. You've heard of the phrase big wigs.
Yeah.
And that comes from the more senior you are, the bigger your wig is. So the Supreme Court judges wear massive, massive wigs, and barristers wear short wigs because we're less important than judges. So the more senior you are, the bigger the wig. So if you see someone with an enormous wig, they're obviously very important. This is a short wig. It took me best part of the year to try and work out the best way to wear it because there are rules. And this is the key to it. Keep everything. Men who are bald struggle, and they struggle because you have to bow. So the idea is these bits should cover the hair at the front, so it needs to be worn slightly forward. You're not meant to see very much hair, so I try and tuck everything in. So there we go. The skirt, obviously. Yeah, so when the judge comes in, you watch a judge come in, you give a long bow, you come up, the judge will bow to you, but you never see it because you're looking at your shoes, and then the judge sits down and then you sit down, and then the case is called on. Well, the usher is called the case as a case of X and X, case number, whatever. Stand up and say, my name is Miss England, IP on behalf of the claimant. My learned friend, Kerry Jones, appears on behalf of the defendant. This is a case about, and you go from there. Oh, and it's very hot in the summer. The rules are strict enough that even in the heat of summer with no air conditioning, everybody has to wear it. But if they say you don't have to robe and you've robed outside of the courtroom, this is the ABBA moment. You go done. It's off. There we go. Any questions so far? Go on.
Very quick one. Are the wigs custom made?
No.
You don't.
They come in size, in different sizes. So when I bought mine, I had to measure my head and then get a size that actually fits. I do have a friend who's got an unusually wide head and had to get one like a special size. But yeah, the gentlemen who are more follically challenged, they're bald, they really struggle because it doesn't stick on particularly well. So as you're carrying on in the day, you see them kind of trying to reposition it. I'm going the wrong way again. Okay, what do I do in particular? So I am in social housing, and that to a lot of people sounds incredibly boring, that I just deal with landlord and tenant matters. It is the widest area of law there is. It encompasses everything from human rights, public law, private rights, you name it, I can deal with different things every day, which is really, really good fun. So I mainly represent social housing providers, that's councils and private registered providers. They're your like Clarion Housing, 18 Dominion, Guinness and Northern Counties, we kind of Peabody, yeah. So all of these will at various times send work into chambers. I think we represent in my particular chambers pretty much all of them in England, or have done at some point. They don't just come to my chambers, they go to a range of chambers because they're enormous. So they will go to different chambers who specialise in social housing. But I'm pleased to say that the chambers I work at is ranked in the top 3. So we get a really good chunk of really good quality work. I deal with a lot of possession claims. Now, when I say possession claims, and I basically am saying I've helped to evict social tenants, that makes me sound absolutely terrible. But it's really, really worthwhile because I deal with tenancy fraud. People who don't need to be and don't deserve to be in social housing, who are taking the place of somebody who really deserves to be. They are fraudulent. About 30% of social housing is fraudulently let in London because the rent is so low at a social rent. If people rent to private renters, they make an enormous profit. So we try and get rid of those people, so people who are disabled in genuine need of housing can take those places. And we see that mainly after the death of a tenant, where the next of kin says, I can inherit this tenancy, and then they go and sublet it. So that's naughty. Failed succession. There's actually a little bit of a problem with empty housing and people not noticing the tenants have died. And then what you do with those empty houses, so I help with that. Antisocial behaviour, nightmare neighbours who make your life a misery. I deal with a lot of those, and I deal with breaches of tenancy, everything from hoarding, and the GPs amongst us, I know, will know a little bit about the mental health problems that go around hoarding. So that isn't about evicting hoarders, that's actually about taking such legal action that forces a person into a corner where they have to get help. And so we do a lot of that. Dogs barking through the night, we do a little bit of that, all sorts of things. Any breach of tenancy you can imagine, I will probably have a little bit of a hand in trying to help the landlord try and sort that out. In things like rent possession, if someone falls behind their rent, it's very rare that we go to court with the idea we're going to evict a social tenant. Most of the time we're actually going to court because if you get an order, you can put pressure on universal credit to pay directly to the landlord, and you're actually also trying to force somebody to accept a little bit of help along the way a lot of the time. Do with injunctions for antisocial behaviour, disrepair claims I've spoken about, homelessness. It's probably the most complicated area of law that I've ever come across. It covers about, there was one main statute that covers all of it, but you're dipping into human rights, public law. By public law, I mean, there's a principle in law that you can't sue the Crown. Like they're just immune. So if you want to challenge a local authority decision, a council decision, you have to go to the High Court for a High Court judge to make a decision about the process that they've come to. And so you have to say they've acted so unreasonably that no other person making that decision would have come to that conclusion. It's called Wednesbury unreasonableness after a case that involved a local authority in Wednesbury, Birmingham. You could say it's disproportionate. You could say they didn't take into account things that they should have taken into account, or they didn't carry out wide enough inquiries. These are attacking the process. You can't attack the decision at the end of it. So those, when I say public law, actually it's a quite nuanced and quite difficult process to actually argue, because you're trying to find in a decision letter at what point, if they'd considered something else, would they have gone down a different line? And so that's public law. So that basically is what we deal with in homelessness. When the decision maker was making a decision about someone's application, actually, did they consider the medical evidence enough? Did they not make an inquiry? Should they have made an inquiry about their medical condition with a doctor who should have seen them, rather than just make a desktop assessment on maybe a GP letter? So all sorts of really interesting issues come up in homelessness. Tribunal claims I deal with a bit. This is where we're not in the county court. I'll show you that in a minute. But when you're in a tribunal about a long lease, so if you own a long lease of the property, the big misconception is that you've bought a house or bought a flat. If you buy a leasehold, you don't own anything. The only thing you own is a deed that lets you stay for a long time, maybe 1,000 years, maybe 100 years. You don't own the bricks and mortar. And so your freeholder is your landlord. So when you own a long lease, I own a long lease, spent a lot of money on it. I probably paid the same amount for a 999-year lease as it would have cost me to buy the freehold. But I live in a block of flats, so I can only buy a lease. The freeholder can still sue me for service charges or any breaches of tenancy, and they can forfeit the lease, which is possession. And forfeiture is literally taking your deed, putting a match underneath it and watching it go up some smoke. If you've got a mortgage, it's now an unprotected debt. So it just goes up and you've got nothing. So what you find if you've got a mortgage, your mortgage lender will step in and do all sorts of things to stop that happening. And I give them advice. Any questions? Go on.
As a barrister, do you actually do the questioning in court?
Yep.
About these matters?
Yeah. So
Can you actually catch them?
It's rare to have an Ally McBeal moment.
Yeah.
But I've had one or two and they're really satisfying.
Yeah, okay.
When you back someone into a corner. I once was cross-examining someone again on disrepair claim. And I have to say the most entertaining cross-examinations happen when you're dealing with antisocial behaviour. But because people just say the silliest things. But the more entertaining thing is I can always think quicker than the person in front of me, because I'm under a lot less stress. Because I do this for a living, I do it day in, day out, I'm used to it, and I've thought about what I'm going to ask, and I've thought about the process, the nice corridor of question I'm going to go through, and I go and close the escape doors. So what I do when I'm preparing a cross-examination, I think, what do I want this person to say? I know I want that person to say that at the end. So in my mind, I'm thinking, what could they possibly say? If I ask them that, if I ask them a direct question about that, they're going to escape. I think they're going to escape through this door. So I need to close that door before I get there. Right. What else could they say? Well, I could ask that and they're going to say this, and I don't want them to say that because that's a problem. So I'm going to, how can I get around that? So in my mind, I'm thinking about all of the things that I have to ask first, so that the only thing that they can say at the end is either stupid or the answer I want. And I'm happy with the stupid answer, because it's a stupid answer. Yeah. So I don't mind the lie because it's obvious. And I can usually see off a lie. I once dealt with a disrepair claim where tenants said there was a buddleia growing through a buddleia is a plant, growing through their wall and in the kitchen, and the roots are coming through the kitchen. And you can see it, there's white paint on the back of the kitchen. And the The guy's cross-examining said, no, there isn't. I said, well, I'll show you a photo of it. And he said, that's a good photo of anything. They could take a picture in the park. I went, yeah, fine. So he's going off and he goes on and on for a good 10 minutes about this, and the judge is looking at me looking like the way Corin's looking at me now, going, we've had half an hour. And so basically, I let him carry on and run out of steam. I had his notes, his handwritten notes of his visit to the property. I said, right, here's go to the first page of your notes. Said, you wrote these, yeah. And this is your handwriting, yes. And only you write in these notes, yes. So everything you say in these notes is true, yes. And it would be unusual if you said something that wasn't true. Oh no, it's all true, it's all true, it's all true. It says this page. Can you just read what you wrote in your notes? Buddleia growing through kitchen wall. Nowhere to go. Right, so this is very small. It appeared bigger on my screen. You won't be able to read it. This is the structure of courts and tribunals in the UK. When I try and explain to people what the structure of the court system is in the UK, it's difficult to visualize, even when you've got it on paper. So I am mainly here in the county court. This is the same line of seniority. So the Crown Court and the magistrate. So this is the criminal end, just criminal. Magistrates, then Crown. You might start a case in the Crown Court if it's an indictable offence, but mainly summary offences are in the Magistrates' Court and indictable in Crown Court. The difference between summary and indictable is how serious is it? So your shoplifting and your petty theft and your I stole a line bike out the front of the building, most of that's here. Most of your fines for your parking, whatever, happens in the magistrates. If you murder someone, you're starting in the Crown Court. So it's about seriousness. The county court actually is split into two, but it is the county court. You've got district judges and circuit judges. District judges have the same seniority as the magistrates, and a circuit judge in the county court has the same seniority as someone in the Crown Court. You mainly wear a wig and gown in front of the circuit judge. It's unhelpfully one court here, but there are rules about where you start them. You then have the Court of Protection, and the Court of Protection protects people who need protecting, so people who don't have capacity to make decisions for themselves, either through mental health or age or some other infirmity. Then you've got the Family Court. The Family Court, confusingly, is a branch of the County Court. But they are generally county court judges with a family court ticket, and they deal with mainly what I would call public law children. Public law children means children who fall under the protection of the state because their parents are unable for one reason or another to look after them. And then you've got coroners' courts at the other end. Coroners basically deal with deaths. So when people die for unexplained reasons, or they end up here. Then you've got the tribunal system. The tribunal is a slightly different system to the civil system over here, because the style of advocacy is different. It's more that they're trying to work out the answers to the problem rather than adversarial way, but one party against another. So you've got tax, people saying, I've got a problem with my tax, and the judge will say, well, what's the answer? Instead of one person being against another person, so well, let's try and work out the answer to your tax affairs, and then we'll just work it out. And same for immigration and asylum, it's just about working out the right answer. Property is working out the right answer about how much service charges people should be paying, and other things to do with building, the intrinsic, like building regulations, what should this material be in a building. Health and social care, you've got social entitlement, that's your benefits, warrant pension and armed forces, and general regulatory chambers. These are just trying to find the right answer when you get into difficulty with the state in some way. And then you've got appeals. appeals, and appeals. So if you want to appeal the magistrate's court, you go to the Crown Court. If you're not happy, you go to one of these courts. If you're not happy with that, you go to the Court of Appeal. If you're not happy with that, you go to the Supreme Court. So most of the decisions happen at this level and are appealed up. Does that make sense? So I don't have to go into detail with these because they are basically appeals. And so that is the court system. And now we're going to get into some fun about advocacy. Anybody, does anyone have any questions about the kind of nuts and bolts of the legal system? No? Fine. Go on.
Can somebody instruct you directly when you have to go barristers? Because I hear more and more people say my barrister, that would be barristers.
Yeah, if you've got a direct public access ticket, this is what I was saying before, you know, some people can qualify the other way. So you can have 2 tickets as a barrister for representing people. You can either have the direct public access, so you can go to the barrister, but you are the solicitor, you manage your own case. Or the second tier up is engaging in litigation, which is writing letters, handling money, doing all those things. So the barrister steps into the solicitor's shoes. So then the client gives it all to the barrister, he does everything. But personally, I've got the first one, not the engaging in litigation ticket. But a person could come to me, but I'm very selective about the cases that come, because it will just take over your diary and you can't give good value for money. So I think if I know that I can give good value for money to somebody coming to me directly, then I will. But that depends on how much the client can actually do themselves. If they can't do that much themselves, then no, go to a solicitor because they'll need a lot of help. Yep.
Over your experience, the period of time you've seen on these cases, have you observed any shifts or changes in kind of our social structure, people's situations? I mean, if you don't feel comfortable saying it, that's fine, but I don't know if you've seen an evolution where the things are getting worse, better, I don't know.
In the legal system?
No, just the people that you're talking to and their circumstances.
No, it's the same. People's circumstances are messy, no matter what. People's dogs bark. People take drugs. People threaten other people. People are unpleasant to other people. People's houses fall out of repair. People are homeless. These things are to us ever us. Okay, advocacy. We're going to rattle through this. Advocacy is what I do. I'm an advocate. There are lots and lots of names that I get called in court, but they're all mostly polite. I am a barrister. The judge calls me counsel. When I sign in at court, I'm counsel, C-O-U-N-S-E-L, counsel. I am an advocate. So I am counsel, advocate, barrister. As far back as Aristotle, people have been persuading other people, further back than Aristotle, but Aristotle had an idea. And I read about this recently and thought, gosh, it's always been like this. He says, of the most modes of persuasion, advocacy, furnished by the spoken word, what we say, there are 3 kinds. The first is a personal character of the speaker, who calls that ethos. The second is putting another person in frame of mind, pathos. And the third is on the proof provided by the words of speech itself. Let's go through these. I think he's talking about personal credibility. How credible is the person that you are talking about? And Aristotle says something clever, because he was like that. We believe good men more fully and more readily than others. And that's true whatever the question is, and absolutely true where exact certainty is impossible and opinions are divided. Welcome to the courtroom. We believe good men. So it's about person, it's about the person who is saying it. And that includes all sorts of things like body language, facial expression, use of the voice, use words, identity in the group, that's a big one, emotional intelligence. What makes a good, how does the judge know who the good man is? Actually, it's in your presentation, but it's your personal credibility. Lots goes into that personal credibility, and you communicate that in various ways. The next is charisma and storytelling. You actually have to want to listen to the person. So that's emotional influence. Aristotle says, our judgments when we are pleased and friendly are not the same as when we're pained and hostile. I think that's true. Our judgments when we're pleased and friendly. So storytelling, giving that personal touch, create curiosity in the audience. And the story allows the speaker to make emotion. It's more like sounding like our American courtroom dramas now, isn't it? And logos, this is our grounding in truth. Persuasion is effected through the speech itself when we've proved a truth or an apparent truth by means of persuasive arguments suitable to that case. So that's content, structure, argument. The relationship of facts and reality. That's a big issue in the courtroom, the relationship with the facts and reality. Sometimes someone's slightly off, but you have to appeal to logic. So, we've been going through the book of Acts in church, and it struck me that all these three things are apparent in the Bible. So, let's go and have a look at how advocacy is used in the Bible. And we're going to look at the Areopagus sermon, that's Paul in Athens, tell you about as these go on. The Jerusalem council sermon and Peter to the Sanhedrin. So the Jerusalem council is when the apostles are talking amongst themselves about whether Gentiles need to be circumcised in order to become Christians. And then Peter is hauled in front of the Sanhedrin for preaching in Jerusalem. So, all of these examples deal with a particular problem. Greeks worship lots of deities, and Paul is telling them there's one God in the Areopagus. That's the problem. The Greeks worship lots and lots of gods. Paul said, no, there's one God. Do Gentiles need to be circumcised? Jerusalem Council is saying, no, grace. And Sanhedrin, just like, who's Jesus? Who is this man who healed this lame man? And Peter and John are there saying, look, he is the Christ. Now, all of these things actually, trying to persuade somebody when there are a division of opinion is difficult, but they manage it through God's grace and a little bit of skill. So the Areopagus sermon, this is Acts. The story is Paul is in Athens and he's, I think, waiting for Timothy to catch up with him. And he's got a few days, he's knocking about town and he's just talking to people. And the Greeks are a sponge for ideas. They're interested. They want to know what's going on and they want to know, and they're interested in what Paul's got to say. And one afternoon, Paul's knocking about and he gets hauled in front of the Areopagus, which is the main debating chamber for all of the great and the good and the intelligent and all of the different opinions, and they want to know what he's saying. And Paul stands up and he's absolutely brilliant. And he stands up and he says, people in Athens, I see in every way you are very religious. As I walked around and carefully looked at your objects of worship, I even found an altar with this inscription, to an unknown God. He has seen and experienced Athens. So this is our first point of call, isn't it? This is the personal credibility. So Paul is establishing himself. I've seen, I've witnessed, and this is what I've done. So, you know, he's capturing his audience. This is the storytelling bit. God, who made the world and everything in it, is the Lord of heaven and earth and does not live in temples built by human hands, and he is not served by human hands as if he needed anything. Isn't this a wonderful story about our God? He's telling him about God. And this is stuff that we kind of take for granted because we're Christians, we know this stuff, but the Greeks didn't. So he's telling him about our one God. Great story. God did this so they would seek him and perhaps reach out for him, though he's not far from any of us. For in him we live and move and have our being. Interesting thing about this is it's a quote, you read, and it's a quote from a Cretan philosopher, Epimenides, and they know that. As some of your own poets have said, we are his offspring. They know that as well. This is from a Stoic philosopher, Aratus. What he's doing, he's pulling together what they know from different opinions, and he's putting them into the pot and saying, actually, you kind of know there's one God already, because there's only one here, and there's only one there. So he's using the context structure and that legal authority that they would recognize from these philosophers to pull it together. And this is where he lands his argument. For he set a day, God has set a day when he will judge the world with justice by the man he's appointed. He has given proof of this to everyone by raising him, Jesus, from the dead. This is the effect of his speech. When they heard about the resurrection of the dead, some of them sneered, but others said, we want to hear you on this subject again. I think that's about as good as it would get in Greece. At that, Paul left the council. Some of them became followers of Paul. Amongst them was a Greek, who was a member of the Areopagus. That is the main council of the people he had to persuade. So we know he's persuasive, and a woman called Damaris, and a number of others. So we know that that was persuasive. I think that's absolutely fascinating. He had authority to speak. They invited him to speak. He told a great story, and he absolutely landed it, drawing in all of these examples. And God used him to move that forward. Fantastic. Jerusalem Council. So we're now at the point where the apostles are talking about whether the Gentiles need to be circumcised. And this is a big debate because for hundreds of years, the Jews have circumcised, and that's kind of, not to get too far into it, but that is a part of their identity. So Peter gets up and he addressed them. Brothers, you know that some time ago, God made a choice among you that the Gentiles might hear from my lips the message of the gospel and believe. So this is who he is. So Peter's got up and God has given him authority to speak. This is him establishing, he's a good man, and it's establishing his history and his authority to speak to them. And he says, now, why do you try and test God by putting on the necks of Gentiles a yoke that neither we nor our ancestors have been able to bear? The yoke was that thing that they put on the oxen to pull the agricultural machinery. Look, we can't bear it. You know, why are we asking the Gentiles to do it? No, we believe it's through the grace of Lord Jesus that we're saved, just as they are. I love this. A whole assembly became silent. They're thinking about it. He's told a good story. He's given the background of their history, and they're all thinking about it. And they listened to Barnabas and Paul telling about the signs and wonders God had done amongst them. So Barnabas and Paul are telling a story. So we've got their authority to speak, and now we've got all the storytelling, and they're putting the audience in an emotion. This is our second element of advocacy. And how did he win the argument, or how was the argument won? Story told compellingly with authority. When they finished, James spoke up. Brothers, listen to me. Simon has described to us, here's our story, how God first intervened and chose a people for his name from the Gentiles. The words of the prophets are in agreement. Here we go, we've got our different authorities coming in, drawing together. And then he gives quite a long quote from Amos, and it's landed. In my judgment, therefore, we should not make it difficult for the Gentiles who are turning to God. So he establishes who they are, tells the story, backgrounds, compelling, and we know that using this authority, drawing these bits of these strands together, that's how they win the argument. Now, final example, Peter and the Sanhedrin. So, I love this story. Peter and John are in Jerusalem with the man who's healed. He'd been lame, been healed, and they're saying, look, Jesus healed this lame man. Jesus is amazing. He's God, he's Christ. Come and believe. So they're in the middle of Jerusalem. And the Sanhedrin have an absolute flip out about it and say, what on earth are they doing? Chuck him in prison overnight. And they're hauled amongst all the great and the good in Jerusalem. And Peter stands up to give an account for himself. This is your, if ever you need some advocacy skill, it's to get out of jail and a system where, frankly, they could do anything to them. Filled with the Holy Spirit, says to them, rulers and elders of the people, if we are being called to account today for an act of kindness shown to a man who was lame, being asked how he was healed, then know this, you and all the people of Israel, it is by the name of Jesus Christ of Nazareth, who you crucified, but whom God has raised from the dead, that this man stands before you healed. What a fantastic account. Are you going to have a go at us because a man's been healed? Is that all you've got? Jesus is the stone you builders rejected, which has become the cornerstone. That's a quote from Psalms. Salvation is found in no one else, for there's no other name under heaven given to mankind by which we must be saved. That's your legal authority. And that's something that the Sanhedrin would have understood. So, how did he succeed in his advocacy? When they saw the courage of Peter and John, realised they were schooled ordinary men, that's their charisma. They were astonished, they took note these men had been with Jesus, there's their personal credibility. But since they could see the man had been healed, standing there with them, there's nothing they could say about it. What a powerful witness. That's the power of a direct witness. So they ordered to withdraw, confer together, what are we going to do? There's no answer. So, what do these tell us? They give us our 3 clues about successful advocacy, as well as the Holy Spirit. They tell us, in order to be persuasive, we need personal credibility, we need to tell a good story, and we need a bit of authority behind us. And that authority could be our own witness, what we have seen ourselves. And that actually is very equipping, because we can all do that. There's no magic. There's no magic in advocacy. It's just about being compelling, telling a good story, and having some authority. We should always be prepared to give an answer to everyone who asks you to give the reason for the hope that you have. Have you ever had that awful moment where you have to catch a train and 10 minutes before you've got to leave, someone says, can you tell me a bit about Jesus? Oh, I wish I could. We're ambassadors, therefore Christ's ambassadors, though God making his appeal through us, so we should allow God to move through us. But today, the rest of what I'm going to talk about for the next 15 minutes, and hopefully for our chats, is how we're going to do that. Relationship is a great starting point, but as I said to you at the beginning, I didn't become a Christian necessarily through relationship, although there was something that came before that to pave the way for me to be confident enough to go to church. Lord does use strangers. We are strangers, and other people can be strangers to us. And I can tell you about that over coffee. But this should be our driving point, love. We felt so strongly about you, we're determined to share with you not only the good news of God, but also our lives. That's how dear you were to us. And I think that should be our cry, not just for the people we know and we love, but also for the people around us. Our personal credibility is our first challenge. If they don't see it in our lives, they're not going to believe it. So this is a challenge to us to be living lives that give us personal credibility. Listen. That sometimes is hard when you think, oh, I've got 5 minutes to tell this. You've got to kind of have a moment, where's this person at? And be prepared. So this is all now about how we can prepare to be great advocates for God. And we're going to talk about these 5 questions. I think if we can answer these 5 questions in 30 seconds in a conversation, that will give us our preparation for talking about our faith with others. And I'm going to be honest now, I took these from a course called Living in Faith. What was your attitude before you knew Jesus? Why did you say yes? How did you say yes? What difference does it make to you? And what is a Christian? over our conversations, I hope you stay and talk about these things. I would love for us to talk about these things and actually what they mean to us. So this is the greatest tip I can give you as an advocate: prepare. Because if I haven't read the papers, then I'm going to be hopeless in court. And if I haven't thought about these questions before someone asks me, then I'm not going to be able to answer them particularly well. So some tips. What was your attitude before you knew Jesus? Does that help somebody else to identify with me? So it's not just necessarily all of these tips, and not necessarily just about me, but like, how does this help me to bring another person to faith? Because ultimately, this is an advocacy exercise for persuasion. You know, let's be honest about it. I want, through my love of this person, for them to come to know Jesus. So, what was my attitude before I knew Jesus? My attitude was, Jesus was probably a man, probably, because I was a historian, probably was a man who walked on earth. The Jews probably hid his body somewhere. I can't explain the resurrection. And frankly, this is the point, this is the crunch point. If you can explain the resurrection, and if that happened, then everything else falls into place. The cross is the starting point for our faith. Why did I say yes to Jesus? I'm going to be careful here, because I don't want my answer to accidentally reinforce that this is a blind faith. I do not have a blind faith. I have a highly informed faith that I am absolutely true and happy to defend in any context, that Jesus was a man. He lived, he was put on trial, he was executed as a criminal. 3 days later, he rose. There are hundreds of eyewitness accounts that show that he was alive and knocking about for about 6 weeks after he was executed, before he was taken up. It is the most recorded event in the ancient world. That tells you something. Why did I say yes to Jesus? Because I was convinced that was true, in fact, in history, and I was convinced it was true because of what Jesus did for me on the day that I gave my life to him. How did I say yes to Jesus? Would someone else know how to say yes from what I said? I said yes in my heart by saying, God, if that's really you, and you're in my heart, then I would really like to get to know you more. And I would really like you to come and live in my heart. And when I prayed that prayer silently in my heart, I felt full of a love so intense that I can't explain. And that is my answer to that. How did I say yes? I said yes by saying yes. What difference does it make, does Jesus make to my daily life? I got some great friends at church. A lot of them in this room. But church is not a social club. Is the difference clearly as a result of my relationship with God, not just coming to church? And if I made sure that I'm not portraying the Christian life as problem-free, what difference does Jesus make to my daily life? I am not alone. Even when things are really, really tough, and they do get really tough, I am not alone. I joked recently, I think, on our WhatsApp group that the path has felt like a Bear Grylls obstacle course at times. And having done a Bear Grylls obstacle course, I understand what that means. There are electric things that electrify you as you run through them, and there's 10-meter waterfalls that you have to jump off, and there's obstacles that you have to climb over under. You don't get a rope. There's a rope thing you have to climb up. There's a thing you have to abseil down. David says in Psalm 21, he leads me through quiet waters. They are not quiet. It's nice to think they might be quiet. Very often I find that they are gushing torrents. But what David also says is that God is a light to the path. And sometimes it feels like if you weren't a Christian, you'd really be knocking around in the dark and falling over things. But the difference Jesus makes is he lights that up and he says, I'm with you. I'm with you to the very end of the age. And even when the wheels fall off, I'm still in the car with you. You're fine. What is a Christian? Can I give a concise explanation of the gospel? Christian is a person who believes that Jesus was a man and he was God. He stood on this planet. He is in my heart, so he's still on the planet. There's some theology with that. Christian believes that Jesus died on the cross, was raised, was resurrected, and loves us so much he would give his life for us. And we're going to spend forever with him in heaven. So, some tips for communication. Avoid using Christian language. It's really, really difficult to avoid using Christian language to people, like when you're talking about this stuff. Your sin's forgiven. I haven't even got a concept of sin. I'm sorry, you lost me already. God is full of grace. I don't even know who she is. Jesus loves you. Doesn't he play for Arsenal? It's really easy as somebody who's lived this, for a number of years, nearly all my adult life, to use technical terms. The world doesn't use these technical terms. We live in a bubble. It's like me coming and using technical language here of the courtroom. I'd lose everybody. Just be real. Just be real with people where they're at. And the famous last words, you will receive power when the Holy Spirit comes on you, and you will be my witnesses in Jerusalem, and in all Judea, and Samaria, and to the ends of the earth. This is a promise we hold on to. He's with us. We will receive that power when the Holy Spirit comes on you. We will receive that power, and that same power resurrected Jesus from the dead, and that same power is in us, and he gives us that power to be advocates for him. So I think that should give us a little bit of courage and boldness. So this is my parting word and my prayer for you. Be confident, prepared, fruitful advocates at the wine bar.